We're back on Morning Barbados with our lawyer on the line, Verla de Pisa, and we were talking about the new Civil Procedures Act.
Civil Procedure Rules. Yes.
Quite a bunch of rules involved in this process, and are you comfortable that there will be immediate benefits under these rules, or is it going to take a while for the whole process to be effective?
I don't think anybody was expecting immediate benefits. It is just like raising a child. First, they need your support through everything, then they learn to sit up, crawl, walk, and eventually run. We're perhaps past the crawling stage now. We're cruising, but like everything, as you practice it, you discover that there are things that you need to smooth out, and we're at that stage where we're trying to iron out the difficulties that we come across, and they do impact not only on the lawyers but also on the litigants. And with time, let's face it, we had the last set of rules since 1982, so they were designed to meet the needs of a different type of society, and perhaps we were ripe for a change. The difficulty I have is that the education did not reach out to the public. We had seminars, the judges went on seminars, the administration went on seminars.
Whose fault was that?
I think everybody has to take a little bit of the blame outside of the public, because each of us has the opportunity to reach out to the public. Perhaps we didn't expect the changes to be so great in practice. When you look at the new rules alongside the old rules, there are several parallels. It is just the manner in which they operate that is different. Going back to witness statements, for example, it is not only the litigants who have to sign witness statements, but their witnesses, third parties, persons who don't really have any interest in the outcome, and getting them to come to sign a witness statement is extremely difficult, because it is something brand new. They never had to do this before. They just had to turn up on the day, and for them it is an inconvenience because most of them work. So we have matters that can be addressed by education.
Stick a pin there, Verla. It's 7 minutes before the hour of 8 o'clock. I think we have Lester on the line. Good morning, Lester.
Good morning.
Good morning.
What's on your mind?
I would like to ask a question for a friend of mine. He's paying a young lady for services, and he got her pregnant. So he wants to know, because he's paying her, he knows the charities, but he said he don't have to support it because he has paying her for services.
Paying for services has so many different meanings, huh? A child is a lifelong investment. It is not a 30-second indicator of anything at all. The fact that whatever the relationship was has reached the stage of pending parenthood, as a father of that child, so long as the paternity is proved, he will have to support the child.
He has a legal obligation.
There's a moral obligation. Yes. If it really were that casual, certain precautions would have been taken.
Let's hear from, I think we have Rodney on the line now. Good morning, Rodney.
Yes, morning. I would like to ask the lawyer. In a case, a civil case, if someone brought a case against you that can prove it, and you won the case and you ask for costs, does that cost, would you have to, that person have to pay your attorney entirely?
No. The word cost is short, but there are entire books written on costs. There are so many different types of costs, and the one that you're thinking about is the costs that come from what we call the cause, costs in the cause. What that is what the court considers to be the cost of bringing the matter in court. That is separate and apart from your attorney's fees and different from the retainer. Usually what happens with those costs, they're either agreed between the parties, or you go to court for what we call a taxation, where the registrar of court will determine what portion the losing side has to pay. It is not necessarily, and hardly ever is, what the attorney's entire fee is, but it definitely is the entirety of your expenses.
Verla, can I get back now to the civil procedure rules and zoom out a little bit and find out where do these fall in terms of the general upgrading and sprucing up of our legislation? We've often heard that we are charging ahead to have a green economy and pull things in place, yet we don't have a domestic violence act on the books or something along those lines. Is this another part of the uneven updating and application of new rules, or are we all moving forward apace together?
Well, it would be difficult to change everything en masse. Well, for one thing, it would be mass confusion. The new rules are designed to fit with technology. Even the paper that we use has changed. It's no longer legal size paper because that's difficult to scan. We can fax. We can serve documents by fax. We can communicate by email. That is accepted by the courts now. The rules are designed for technology. Whether or not that has actually happened yet is a completely different story. But then you have to change the mindset of attorneys as well to move towards technology, because of course paper is safer for us because there's a record. Paper doesn't crash, and we do feel a little bit more security in having a physical document, and clients do too, to a certain extent. But we are moving towards, as far as the rules are concerned, moving towards the ability to serve documents and file documents without moving from your desk.
So you can serve a document by email, in effect?
We can serve a document by email in theory. I don't think anybody's actually done it yet. We can serve by fax. We have been doing that one. Communications, that as they have changed, have been embraced by the rules. They now have to be embraced by the practice. We'll get there. Okay. There's software that has been developed to assist, and the registry has a software. All the documents are scanned. I think there needs to be a greater investment in the hardware so that it is actually physically present in the court. But we can use technology in the courts now. We take our notebooks and laptops and iPads to courts. Unfortunately, even though it is wireless, inside the courts you don't get the signals, so you still have to use wired. But at least the access is there. So we're getting there.
I've often wondered though about taking information in court. We haven't always had a court reporter, and you had to rely on the memory of the magistrate or the judge. Have we evolved past that?
It may seem as though you're relying on the memory of the magistrate or the judge, but in both cases, what we had before, our courts are courts of record. What that means is everything is written down in books, hardback books that are expected to last.
Loose leaf binders.
Yes. So we are a court of record, and we've had that for a while. The stenographers now are electronic stenographers, so we can get our transcripts by the next day. So that is in criminal. We're moving towards that in civil. We have it in the Court of Appeal now, so we're getting there.
Well, for the first time, Verla, you brought some good news, because I've often joked that you always depress me. But good news on the civil procedure rules. They're moving apace, and hopefully litigants and lawyers alike will benefit. And today's swearing day for our new Chief Justice. We'll keep you updated on that. Thanks a lot for joining us again.
To you, sir.
Thanks a lot for joining us. Verla DePisa is our lawyer on the line, bringing to the end our program. It was good to join you.
Good to see you. Wonderful, wonderful program today. Morning, Barbados.
Wake up, wake up.